Good morning, everybody. How is everybody doing? I'm your host, the Supreme Litigant, and I'd like to welcome everybody back to Smart Loc TV. Before I begin, y'all already know the routine. Please hit that like and that subscription button and turn that notification bell on. I'll give y'all a second to do that if you haven't. All right, so I'm going to jump right into this. So I have something. I'm trying something out, but so y'all just bear with me. This is a little new for me, so I've managed to split the screens so that y'all can see their argument. This is defendant's motion for summary judgment, and then you'll see my response in opposition to defendant's motion for summary judgment. Now, if you look on the docket for my case, you will see their motion for summary judgment, but you won't see my response in opposition uh, to their motion for summary judgment because we settled the case before I filed it. I think we settled back in June of 2022, something like that. So we settled the case in federal court, and they cut me a check or whatever. But anyway, um, so what I'm going to do is I'm not going to focus on what they're saying right here or what I'm saying right here. I'm going to focus on the causes of actions, the disputes within the causes of actions. Um, let me rephrase that: the disputes of the facts of what happening. Of what happened. So here they are arguing their set of facts. Okay, that's what they're doing in here. They're arguing everything that they believe is relevant to getting their motion for summary judgment granted. Now, I do want to let y'all know that whenever you get a defendant's motion for summary judgment, if you are a plaintiff, you need to read that thoroughly because they will lie. They will misrepresent facts because they're trying to get that motion granted. I'm telling you what I know. They will do that. So how do you beat it? How do you respond to a motion for summary judgment if you're a plaintiff uh, and the defendant has moved for this particular judgment against you? The way you do that, the way you defeat it is you have to show that there is a one genuine issue of a two material fact um, in three dispute. So you have to show that there is a genuine issue of a material fact in dispute. If you can do that, they will not get summary judgment. So what do I mean by that? I'm going to substantiate that and just let y'all know what I mean here. It's gonna be in my paperwork. It's not gonna be in theirs. I looked, I didn't see it in there, so it's gonna be in mine. But essentially this part right here. They're arguing their set of facts. They're trying to get their motion granted. What I'm doing is I am disputing their set of facts. You see what I'm saying? I'm disputing their set of facts because the facts that they're arguing, they are genuine and they are material to determine the outcome of the case. That's why I am disputing them with my recollection of the facts here. That's all that we're doing in these particular sections right here. That's it. So I think they're started on probably page 9. Yeah, it did for their argument. Started on page 9. So, uh, and I'm not sure where mine started at. What is all this stuff? Sorry about these pop-ups, y'all. I don't know what that is. I'm not sure where mine's started. Let me see. Man, give me a second, y'all. I'm gonna pause the video. I don't want to waste y'all time, so give me a second. Okay, I found it, y'all. Got it. Okay, so what we're gonna do here is I'm gonna read you theirs. I'm gonna read you everything that they are arguing against my particular cause of action, which would be an unreasonable search and seizure. I think I put unlawful search and seizure in mine. Um, and then once I finish reading theirs, I'm going to read you the standard for summary judgment, and then I'm going to read you my response in opposition to them arguing against my cause of action, my first cause of action. Hopefully that makes sense for y'all. Presumably, plaintiff is pursuing a 1983 action against the officers. To state a Section 1983 claim, plaintiff must establish that the conduct complained of was committed by a person acting under color of state law, and that this conduct deprived the plaintiff of a federal constitutional or statutory right. And then there's the case that they're making in support of their argument. However, Section 1983 is not itself a source of substantive rights, but merely provides a method for vindicating federal rights elsewhere conferred, so on and so forth. See how they're citing their authority for saying what they're saying? That's how you have to do it. Thus, the first step in analyzing any such claim is to identify the specific constitutional right allegedly violated by the defendant. Okay, let's see. Roll down. Once the particular constitutional right is determined, the court must then apply the standards applicable to that particular constitutional provision to determine whether a constitutional violation has occurred. Graham versus Connor. In addition, plaintiff must establish a causal connection between the defendant's actions, customs, policies, or statutorily imposed duties and the alleged deprivation of plaintiff's constitutional right in order to state a claim upon which relief may be granted. You're going to see them cite, primarily in their opinions and in my opinions, we're either going to cite U.S. Supreme Court cases or we're going to cite the 11th Circuit. The reason for that is because all U.S. district courts in Alabama, Georgia, and Florida all of their appeals go to the U.S. Court of Appeals for the 11th Circuit. That's why you're going to see that in here. Let's see. There is no dispute that the officers were acting under color of state law. So what he's saying is he's not arguing that they were not acting under color of state law. That's what they're saying. As for the deprivation of a specific constitutional right, plaintiff alleges an unreasonable search and seizure. The Fourth Amendment protects individuals from unreasonable searches and seizures. He has a footnote right there, so that means you have to go down and go to the second footnote, and they must have made another argument down there. Thus, the question is whether an unreasonable search and seizure occurred. There you go. That's the standard. This is not a case where a police officer simply demands someone on the side of the street to identify himself and then seizes his identification. There is no doubt that on the night in question, Davis committed a crime. It is undisputed that Davis was operating a motor vehicle. Are y'all paying attention to these commercial terms that they're using? Anyway, which he parked in the middle of the highway when it stalled. And that he refused to provide his driver's license multiple times following requests by the officers. Alabama law requires him to produce his driver's license upon request by a police officer. That's true. But y'all will hear me argue my case in a minute. I'm not going to even say anything about mine. But just pay attention. And then he cites this. Every licensee shall have his or her license in his or her immediate possession at all times when driving a motor vehicle, and shall display the same upon demand of a judge of any court, a peace officer, or state trooper. Remember when I said that the footnote 2, they said something that says Davis claims his right to be secure in his person against unreasonable searches and seizures as granted by the 4th and 14th Amendments was violated, whereby plaintiff was unlawfully detained. This seems to implicate, 1, an unlawful search and seizure, and 2, an unlawful detention. Unlawful detention is essentially a false imprisonment claim and will be addressed under plaintiff's third cause of action. See what I'm saying? So they're arguing their case pretty good, but they're misrepresenting the facts. And this goes back here, Alabama Code, Section 3269. That's what they were talking about when they were saying that I was required to produce my driver's license on demand. Notice there's a statute right there, just to let y'all know, because police officers are foreign to common law. They did not exist at common law. They exist only via statutes. They were created by the legislature. So the legislature can abolish all police departments at will whenever they want. The only one that they cannot abolish is the sheriff, because they did not create the sheriff. The sheriff did not get her or his authority from the legislature. They got it from the sovereign people of Alabama. And that is the only one who can fire the sheriff. Let's see. One can be arrested and convicted of a crime for violating this statute. Notice they're talking about a statute, y'all. Once Davis refused to provide his driver's license, there was probable cause to arrest him. Under these circumstances, the officers are entitled to qualified immunity. Qualified immunity offers complete protection from governmental officials sued in their individual capacities if their conduct does not violate clearly established law. Let me rephrase that. If their conduct does not violate, I'm trying to read too fast, clearly established constitutionally, I'm going to say constitutionally protected rights. I'm not even going to read the statute, but yeah, it says statute, but I don't really like doing that. But anyway, rights of which a reasonable person would have known. To be entitled to qualified immunity, an individual defendant must first show that he was a public official acting within his discretionary authority when the allegedly wrongful acts occurred. Notice that you're going to see all these 11th Circuit cases. This is how you argue your case, y'all. This is how you do it. The 11th Circuit has further stated that qualified immunity is available to a governmental official so long as the official's actions were taken pursuant to the performance of his duties and were within the scope of his authority. A government official can prove he acted within the scope of his discretionary authority by showing objective circumstances which would compel the conclusion that his actions were undertaken pursuant to the performance of his duties and within the scope of his authority. The showing made by appellant in the two affidavits attached to this alternative motion for summary judgment adequately demonstrate that his actions in conducting the investigation and writing and submitting the probable cause affidavit at issue were carried out in the performance of his normal job duties and were within the authority delegated to him by his employer, the state attorney. Courts routinely look to state law to determine the scope of a defendant's discretionary authority. As stated by the 11th Circuit concerning Alabama police officers, investigating and prosecuting violations of the law clearly falls within the scope of official duties of law enforcement officers. Police investigations and arrests usually are considered discretionary functions within the line and scope of law enforcement duties for the purposes of discretionary function immunity. Let's go down here. Law enforcement officers perform discretionary functions when they exercise judgment in the enforcement of the criminal laws, including gathering of information and subsequent arrests. And, generally arrests and attempted arrests are classified as discretionary functions. Decisions as to the use and amount of force are discretionary. Police investigations and arrests usually are considered discretionary functions in the line and scope of law enforcement duties for purposes of immunity. There is little doubt that the officers were public officials acting within their discretionary authority at the time of the incident. The officers were patrol officers whose duties included patrolling the streets, keeping the public safe, enforcing traffic rules, detaining potential suspects, making arrests as needed, etc. And on the night in question, they encountered a vehicle parked in the middle of the highway with a bad tag and a driver who refused to provide his driver's license. Pay attention. I told y'all they'll misrepresent. Look, they'll lie about whatever they can. They're going to lie to try to get this motion granted. That's what they do. Whether their actions that night were correct is not the issue. The inquiry is not whether it was within the defendant's authority to commit the allegedly illegal act. Instead, a court must ask whether the act complained of, if done for a proper purpose, would be within or reasonably related to the outer perimeter of officers' discretionary duties. Once a public official's discretionary authority is established, the court must conduct a qualified immunity analysis. There's their case to support their contention. The United States Supreme Court sets forth a two-part test for this analysis. Under Saucier, the threshold inquiry a court must undertake in a qualified immunity analysis is whether the plaintiff's allegations, if true, established a constitutional violation. In other words, the court must determine whether the plaintiff has even alleged a constitutional violation at all prior to addressing the question of whether the constitutional right was clearly established at the time of the incident. This is why you need to show a clearly established constitutionally protected right has been violated in your complaint. If you do not do that, they're going to file a motion to dismiss. They might file a motion for summary judgment based on that, on qualified immunity grounds. You ain't getting nowhere until you do that. You have to do that. If the court determines, looking at the facts in a light most favorable to the plaintiff, that a constitutional right would have been violated, the second step under Saucier is to ask whether that particular right was clearly established at the time. Subsequent case law established that judges are now permitted to exercise their sound discretion in deciding which of the two prongs of the qualified immunity analysis should be addressed first in light of the circumstances in the particular case at hand. It is not clear that Davis had alleged violation of a constitutional right that had clearly been established. To the contrary, prior case law establishes that under these circumstances, the officers had a right to search Davis. And I'm guessing this is a case in support of their argument. This is a Louisiana case, a federal Louisiana case. A case with many facts similar to this. A police officer observed the plaintiff running a red light, parking his vehicle at his place of business, and then walking to the entrance. How is that relevant? That's not relevant at all. Anyway, the officer approached the plaintiff and asked for his driver's license, but the plaintiff refused, stating that he was not driving at the moment. Yeah, that's completely irrelevant. All of this is irrelevant in my case. Anyway, the vehicle did not have a license plate. The officer called for backup and other officers arrived. The plaintiff was asked again for his driver's license and he refused. Okay, that would be relevant, but this other stuff, that's irrelevant. Another officer grabbed him by his arm, pushed him, and then approached him aggressively and removed his wallet from his pockets. Plaintiff was handcuffed and placed in a police vehicle. His vehicle was towed. He was then released and issued a citation for running the red light and not having a license tag on the vehicle. All of that's irrelevant in my case. The court noted that a search incident to arrest can properly include inspection of a suspect's wallet. The court further noted that the officers knew that plaintiff had violated Louisiana traffic laws and also refused to produce his license in violation of blah, blah, blah statute. Person operating a motor vehicle must display his driver's license when requested by a police officer. The court held that the officer was entitled to qualified immunity because it was objectively reasonable for the officers to search plaintiff's wallet. I agree with that. If they saw him, violate a traffic violation or whatever, we're not even going to get into the right to travel and all that stuff. I'm not going to mention any of that in here. That's irrelevant for right now. I agree with that. In another case, the Fifth Circuit likewise found qualified immunity where the plaintiff failed to show that it is clearly established that a limited search for the sole purposes of procuring identification after an uncooperative arrestee refuses numerous requests to identify herself violated the Fourth Amendment. Another similar case is Evans versus Solomon, blah, blah, blah. So this is a New York federal case. In that case, an officer stopped the plaintiff for running a red light. Notice these facts are not similar. Some of them are and some of them are not. The officer asked for the plaintiff's license and registration multiple times, but plaintiff refused. Other officers arrived on the scene, and plaintiff was again asked for his identification, and again he refused. The first officer then grabbed plaintiff's right wrist, turned it behind his back, and pushed him up against his vehicle. With plaintiff pinned against the vehicle, the officer pulled his wallet out of his pocket and pulled his driver's license from the wallet. Plaintiff at this point began pacing back and forth the length of his vehicle adjacent to the lane of traffic. He exchanged some words with the officers, rolled his eyes, turned towards his car. Turned towards his car. I'm sorry, y'all. At that point, the officer handcuffed him for his own safety and placed him in the police vehicle. So let's see. This is a footnote. I'm not going to read. I'm going to keep reading this. The court held that the officer's conduct did not amount to a constitutional tort. The officer argued that because he had probable cause to arrest plaintiff, notice that he had probable cause, he had a lawful purpose to arrest plaintiff for failing to produce any identification, plaintiff was subject to a search. So what they're saying is if there's a lawful purpose for the police officer arresting you or detaining you, then they can search you. Plaintiff was subject to a search to obtain his license in his pants pocket. The court construed this argument to appeal to the search incident to arrest, exception to the warrant requirement for a search and seizure. So basically what they're saying is a search incident to arrest is an exception to a warrant requirement for a search and seizure. When police effect a lawful arrest, notice the arrest has to be lawful. Notice they use the word lawful. They don't say when the police effect an unlawful arrest. No. When police effect a lawful arrest, they may conduct a full search of the arrestee's person without any additional justification. It has to be lawful, y'all. It has to be lawful. And if it's not lawful, then they can't use none of the evidence against you. You don't have to do nothing they say. Nothing. The court noted that the officer undoubtedly had probable cause to arrest plaintiff based either on plaintiff's traffic infraction or his refusal to furnish a driver's license. Yeah, because he was lawfully stopped and lawfully. Well, I ain't gonna say lawfully stopped because we talking about driver's license and all that. Whatever. Anyway, the court stated that an arrest pursuant even to a simple traffic violation permits a search incident to arrest. The court held that once the officer acquired the authority to arrest plaintiff, he was permitted to conduct a full search incident to arrest. It follows that once the police had probable cause to stop and arrest, Scopo, they were entitled to search both him and They were entitled to search both him and his grab space in the car. Oh, okay, I see what they're saying. The court noted, but dismissed one potential difficulty. But dismissed one potential difficulty with its analysis: the fact that the officer did not end up placing the plaintiff under arrest. The court noted that the Supreme Court itself previously stated that a full-blown search incident to arrest is permissible merely by virtue of the lawful arrest, stating a custodial arrest of a suspect based on probable cause is a reasonable intrusion under the Fourth Amendment. That intrusion being lawful, a search incident to the arrest requires no additional justification and does not depend on what a court may later decide was the probability in a particular arrest situation. In a particular arrest situations. Sorry about that, y'all. Let me go down some more. In a particular arrest situations, that weapons or evidence would in fact be found upon the person of the suspect. The court further noted that Courts analyzing a search incident to arrest focus solely on the officer's action at the time of the search rather than on any subsequent event. Approaching search even though no arrest was made. Not approaching. I'm sorry, y'all. I'm trying to read so fast. Approving search even though no arrest was made, reasoning that the fact that the officer had cause to arrest the plaintiff for speeding, even if he initially determined not to do so, was a sufficient predicate for a full search. Notice how they argue in this case, boy. They don't look. They trying to get out of it, y'all. They trying to get out of it. I'm not gonna. Let me see. Should I read that? Applying these principles, an officer should be entitled to something. I'm not gonna read that. Y'all can read it if y'all want. Just pause the video and read it. Let's see. Here, the court finds that, like in Evans, the search was reasonable, was justified as a search incident to arrest, and under the circumstances, was not made unlawful by a later decision not to arrest. There is no clearly established right that was violated by the officers in this case, specifically stating that even if a search was unconstitutional, no contrary clearly established law put an officer on notice that he could not search plaintiff's purse for her driver's license. I don't know what they talking about right here. It does not follow immediately from the premise that because the right to be free from warrantless searches, absent probable cause or exigent circumstances, is clearly established under the Fourth Amendment, that all law enforcement searches not supported by probable cause or exigent circumstances must be deemed objectively legally unreasonable for purposes of the application of the qualified immunity doctrine. The test for qualified immunity is one of objective reasonableness, whether an officer acting under the circumstances at issue reasonably could have believed that his action would not violate the constitutional rights asserted. Harlow versus Fitzgerald. Reasonableness is to be assessed from the perspective of the reasonable officer on the scene rather than with the benefit of hindsight. It is inevitable that law enforcement officials will in some cases reasonably but mistakenly conclude that probable cause is present. This is how they get immunity, y'all, when they violate the Fourth Amendment, just to let y'all know, because they can violate the Fourth Amendment and still get immunity if they act reasonably, even though they acted mistakenly. That's how they do it, y'all. Anyway, it is inevitable that law enforcement officials will, in some cases, reasonably but mistakenly conclude that probable cause is present, and the real question is whether a reasonable officer could have believed a warrantless search to be lawful. The purpose of qualified immunity is to allow government officials to carry out their discretionary duties without the fear of personal liability or harassing litigation. I'm gonna tell y'all something, man. I personally do not believe that qualified immunity, which is essentially what the Supreme Court made up, should apply to any police officer that was created via statute. No police officer made via statute because it's under another jurisdiction. It's not common law jurisdiction. Now, if it were the sheriff, I believe that particular standard, qualified immunity, should apply when it is necessary to apply. Let's see. As such, qualified immunity protects all but the plainly incompetent or those who knowingly violate the law. Officer Breland here testified that Davis was parked in the middle of a 5-lane highway with no lights on, that there was an issue with the vehicle's tag, that Davis refused to produce his identification, that Davis was acting agitated and evasive, that Davis disobeyed commands to walk toward Breland and instead walked away from him to the other side of the vehicle, that it was dark and Breland was concerned about he and Davis being in the middle of the highway, and that even when two other officers arrived, Davis refused to provide his identification. At that point, Davis at that point clearly had violated Alabama law and put him and three other police officers in potential harm's way. Temporarily detaining Davis and searching him and obtaining his identification was reasonable under the circumstances. This is how you have to argue your case, y'all. Even though they lying, but this is how you have to argue your case. And should not be second guessed years later. So that's the first one. Okay. That's the first argument for their cause of action. There's a footnote down here, so let me go and read their footnote too, because I think that's relevant. Kind of long, anyway. Okay, the officers had authority to search Davis under the exigent circumstances exception to warrantless searches, which is that's one of the exceptions to a warrantless search, exigent circumstances. As stated by the 11th Circuit, it is not a court's role to armchair quarterback the officer's decision, and in assessing the reasonableness of officers' actions, we cannot indulge the 2020 vision of hindsight, but instead must adopt the perspective of a reasonable officer on the scene. Now, this reasonable officer on the scene does not exist, y'all. They made up reasonable officer. And they use that to determine if the real officer on the scene acted in a lawful manner, meaning acted in a reasonable manner. A court can get caught up in facts. A court can't get caught up in facts that the officers couldn't have known at the time. Rather, we must be mindful that police must act quickly based on hurried and incomplete information. Put simply, the Fourth Amendment's reasonableness requirement gives officers facing exigent circumstances ample breathing space to do the best they could with the information they had. Nowhere is this breathing space more crucial than in situations where life and limb may be in jeopardy. Okay, so that's their argument to my first cause of action. So now I'm going to read to y'all the legal standard for summary judgment, and then I'm going to read y'all my response against their argument against my first cause of action. Hopefully that makes sense for y'all. I'm sorry this stuff is so wordy, but you got to bear with me. So, all right. Summary judgment legal standard. Summary judgment may be granted only if the movement shows that there is no genuine dispute as to any material fact, and the movement is entitled to judgment as a matter of law. And there's the footnote right there. See this footnote? In determining whether a genuine dispute of material fact exists to defeat summary judgment, the evidence is viewed in the light most favorable to the party opposing summary judgment, drawing all justifiable inferences in the opposing party's favor. A fact, now this is what they're going to tell y'all what they mean by material and genuine right now. That's why you see these in italic. They've been construed. They've been substantiated. These terms have been substantiated. A fact is material if it is relevant or necessary to the outcome of the suit. A factual dispute is genuine if the evidence would allow a reasonable jury to return a verdict for the non-moving party. That is why we are arguing over the facts. Let me rephrase that. That is why we are arguing over the genuine issue of material facts. That's why we're arguing over. Since we're arguing over them, they're being disputed. There's an argument going on about what actually happened. And whenever there's an argument going on about what actually happened, then the case goes to the jury for the jury to decide, because the jury could return, the jury could say that they are entitled to qualified immunity, or the jury could say that they are not entitled to qualified immunity. Does that make sense? Let's see. The non-moving party must go beyond the pleadings. They're talking about me because I didn't move for summary judgment. So if you didn't move for summary judgment and you're a plaintiff in the case, this applies to you. The non-moving party must go beyond the pleadings and point the court to specific facts showing a genuine issue for trial. And you see how I'm citing my authority for saying what I'm saying? Same way they did. That's how you have to do it. The non-moving party is not required to produce evidence in a form that would be admissible at trial, but it must point to some evidence to show a genuine issue of material fact. Such evidence may be in the form of affidavits, depositions, answers to interrogatories, or admissions on file. See all of this? This is easy, y'all. Very easy. So now I'm going to argue about, now I'm going to, I'm giving the court the law on qualified immunity standard, the qualified immunity legal standard. In determining whether or not a police officer is entitled to qualified immunity, the court's analysis turns on whether the police officer, in the exercise of his or her discretionary authority, violated clearly established statutory or constitutional rights of which a reasonable person would have known. In other words, qualified immunity shields police officers acting within, not without, meaning outside, acting within the scope of their discretionary authority from liability, so long as their acts do not violate clearly established law. And there's the footnotes right there. Clearly established law is law that is sufficiently defined so as to provide public officials with fair notice that the conduct alleged is prohibited. If the evidence at the summary judgment stage, viewed in the light most favorable to the plaintiff, shows there are facts that are inconsistent with qualified immunity being granted, the case and qualified immunity issue alone will proceed to trial. Might have read that wrong a little bit, but y'all get what I'm saying. And then here's the footnotes right here. So I'm gonna read y'all footnote 10 because y'all need to know that. So let's see. Only Supreme Court, 11th Circuit, and Alabama Supreme Court cases can clearly establish the law in this litigation, in my particular lawsuit, because this happened in Alabama. I'm litigating the case in a U.S. District Court in Alabama. The U.S. Court of Appeals for the 11th Circuit is the federal appellate court for the U.S. District Court in Alabama. And everybody know, y'all already know this stuff. I shouldn't even have to explain this to you. Y'all should get it just by me telling y'all that. Anyway, in this circuit, rights are clearly established by decisions of the Supreme Court, this court, or the highest court of the state in which the case arises. Just so y'all know that's how clearly established law is established, if that makes sense. Also, you have to when you get evidence from the police department, like their general orders, that's clearly established law. If they violate the policy or something like that, they're not going to get immunity for that. They're not going to get immunity. If they violate any policy, statute, case law, rule, or something like that, they're not going to get immunity. They just ain't going to get it. But you have to get the evidence, and you have to properly argue the evidence to prove your point. So here we go right here. This is my argument right here against their argument. So 1, defendant's motion for summary judgment as to plaintiff's first cause of action on qualified immunity grounds should be denied. And I have a footnote right there. So when I finish this page, I'm going to read y'all. I might have to read y'all all these footnotes. Shit, I don't want to, but I might have to read all of them to you. Defendants contend that they allegedly had probable cause to arrest plaintiff pursuant to Section 3269 of the Alabama Code 1975 because plaintiff refused to provide identification when requested and therefore allegedly exercised their discretionary function when arresting and detaining plaintiff, which allegedly entitles them to qualified immunity as a matter of law. That's what they're arguing. Plaintiff disputes this contention to the extent that they separately or collectively imply plaintiff was lawfully required to comply with defendant's prima facie request. Notice I said a request and not order. During a prima facie consensual encounter where defendants violated clearly established law of which a reasonable officer would have known. Moreover, Section 3269 of the Alabama Code 1975 does not and cannot lawfully give police officers carte blanche to arrest and detain for refusal to obey any demand they may choose to direct at plaintiff. Plaintiff's only duty is to comply with lawful orders. That is all you are required to do. You have a duty to comply with lawful orders. That's it. That's it. Averred thoroughly, plaintiff, an objectively reasonable person, asked Breland a reasonable question, and I did. To which Breland replied, because you're broke down in the middle of my highway and I don't know who you are, or I just want to know who I'm talking to. I don't care what you said. That gives you no lawful purpose to arrest me and put me in handcuffs. Anyway, after witnessing these exculpatory answers of Breland, plaintiff then reasonably concluded, as any other reasonable person would have, that he was not lawfully required to comply with defendant's prima facie request. It's a request. It's not an order. It's a request. Defendants had no authority to enforce neither the provisions of that statute nor any other statute because no offense was ever committed. But had that offense alleged by defendants been committed, plaintiff would have simply complied because then defendants would have, emphasis added, issued two lawful orders which, if either then refused by plaintiff, emphasis added, would warrant a reasonable officer to believe plaintiff committed an offense in their presence, thus making that arrest and detention of plaintiff, let me rephrase that, thus making that arrest and detention of plaintiff lawful, which would then immunize defendants from suit. I know when I'm giving an unlawful order, and I know when I'm not giving an unlawful order. That's why I asked him. I asked him a question. Why do you want my ID? And this idiot said, because you broke down in the middle of my highway and I don't know who you are. I just want to know who you are. I don't care. Being a stranded motorist is not a crime. Being broke down in the middle of the highway is not a crime. It's not even an offense. So when he said that, y'all, I reasonably concluded that I was not lawfully required to comply with his request. See how easy that is, y'all? Let's go back up here to number 12 because I want to show y'all something. Where is it at? Right here. So right here I said, moreover, 3269 of the Alabama Code 1975 does not and cannot lawfully give police officers carte blanche to arrest and detain for refusal to obey any demand they may choose to direct at plaintiff. And you see that footnote right there? That's 12. So let's go down here. Let me read that footnote. McCorvey versus Smith. A police officer cannot give an unlawful order and then base probable cause for an arrest on a citizen's refusal to obey that unlawful order. You just can't do that. You can't do that. You can't do it. Look, I know that drives y'all police officers crazy that you can't do that. But you can't do it. You just can't do it. It's unlawful. Boy. Plaintiff avers that he was undoubtedly a stranded motorist and that this was a consensual encounter. And during consensual encounters, plaintiff may either voluntarily comply with defendant's requests or choose to ignore them because the Fourth Amendment's mandate of either reasonable suspicion or probable cause is not required. And there's a footnote right there. I'm going to read y'all that footnote. I think I'm going to do it like that. 16. There's a United States Supreme Court case right there that supports everything that I just said in that footnote. In my argument up there. Because plaintiff was free to decline the officer's request or otherwise terminate the encounter, which plaintiff attempted to do twice. I tried to do that twice, but they just so hard. It just drive them crazy, y'all. You got to give us. You got to give it to me. You got to give me your ID. You got to get. I know what I'm talking about. I'm the police. You got to listen to me. Man, shut the fuck up. You don't know what the fuck you're talking about. You don't. So if this ever happens to you and you know the law, do not argue the law with police. Just act like you don't. Act like you don't know what's going on. You need to be as green as grass. Just act like you don't even know, because once you start letting them know you do know, they might come up with some false charges against you, so you can't sue them. Which plaintiff attempted to do twice, emphasis added, prior to defendant's unlawful actions. In fact, the only reason plaintiff refused to comply with the two requests of defendants is simply because plaintiff did not have to, since being a stranded motorist is neither an offense in Alabama nor is refusing to provide identification during consensual encounters in Alabama. And there's another footnote right there. And I'm citing nothing but cases. You can go read the cases. Go read the cases. I'm not going to do y'all work for you. Go read the cases. See that? All the cases right there. All the cases right there. For defendants to be entitled to qualified immunity, actual probable cause is irrelevant, since the proper standard is arguable probable cause, which I hate. Arguable probable cause, but y'all need to pay attention, because this is also how you beat qualified immunity. They can if they have probable cause, arguable probable cause, or reasonable suspicion, or arguable reasonable suspicion in regards to your Fourth Amendment, like unlawful arrest or unlawful detention or something like that. If they have that, they're going to get immunity. If they have any of what I just said, they're going to get immunity. If they don't have any of what I just said, they're not going to get immunity. So y'all need to pay attention, because I'm about to explain to y'all what arguable probable cause is. Arguable probable cause exists when an officer reasonably could, exists when an officer reasonably could have believed that probable cause existed in light of the information the officer possessed. As we framed in the concept of Lee Ferrero, arguable probable cause exists where reasonable officers in the same circumstances and possessing the same knowledge as the defendant could have believed that probable cause existed to arrest. In determining whether arguable probable cause exists, we apply an objective standard, asking whether the officer's actions are objectively reasonable, regardless of the officer's underlying intent or motivation. So now we're going to talk about the facts, because who better to argue the facts of your case than you? The only facts Breland knew of after he arrived on the scene was that plaintiff was tired, mentally exhausted, his car had recently broke down, and plaintiff's name was Isaac. That's all he knew, y'all. How do I know that? Because I'm a witness. And because I know what to say and what not to say. And that is all he knew. And ain't none of that a crime per se. Holyfield and Morgan did not know of any facts. Holyfield and Morgan did not know of any facts. Holyfield and Morgan did not know of any facts whatsoever about the incident until after they, along with Breland, arrested and detained plaintiff. The fact that plaintiff refused to provide Breland his ID, let me rephrase that again. Y'all need to pay attention. The fact that plaintiff refused to provide Breland his ID, was frustrated and mentally exhausted, is not, per se, criminal activity or an indication thereof. This was a prima facie consensual encounter that defendants knew or should have known, since a holding of which the Fourth Amendment's mandate of probable cause and reasonable suspicion apply is, in fact, clearly established law of which a reasonable officer would have known. Thus, reasonable officers confronted with these same facts and circumstances as the defendants would not have believed that probable cause existed to arrest plaintiff, and therefore, as a matter of law, defendants are not entitled to qualified immunity as to plaintiff's first cause of action, nor as to plaintiff's second cause of action. Okay, I think that's how long we are. Yeah, we had 50 minutes already. Okay, I think that is pretty good. If y'all are learning from this, let me know. And what I'll do is I'll keep doing this until it's finished. So I read y'all the next cause of action. I read y'all their next argument, and then I go back and read y'all my response in opposition to their argument in regards to my second cause of action. So if this is helping y'all, please let me know. Please, 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 please let me know. And if y'all want me to, just go through the whole entire these two documents, just let me know, and we can just go from there. Hopefully, again, this helped. That'll be the end of this video. The Supreme Litigant is out. Peace.